Well, let's inject some legal perspective, and who best to do that for us? Daniel Bwala, a legal practitioner, joins us this morning. Thank you for coming on this morning. Break this down from the perspective of the law. A lot of hoopla about this kind of matter, but what do you think, provisions of the law on this case?
Well, thank you for having me. There are quite a number of issues to look at, but first of all is to look at whether or not someone is charged. There is no doubt in the fact that the Senate President and the Deputy were charged to court on the account of forgery and conspiracy and forgery. And my opinion is, when someone is charged to court, you are presumed innocent until you are proven guilty. And the onus of proving that you are guilty lies on the prosecution, so you don't have to worry much when you are charged to court. And then another important thing is that there is remedy in law in case you are maliciously prosecuted. And we have had that over time in Nigeria where, for example, the former governor of Adamawa State got a judgment against EFCC for malicious prosecution, and even Governor Fayose of Ekiti at one time also got a judgment against EFCC again. So if you are charged to court, if you feel that you haven't committed the offense, go and defend yourself. At the end of the day, if it is proven that you are not guilty, then at that point you can take it up against the government and then file an action for malicious prosecution and then see where you go from there. But the truth of the matter is that once there is a charge against someone, the rule of law demands that you go and defend yourself.
Then the other perspective about this, yes, you could also remedy that by seeking for some malicious prosecution, but they also say that, look, there's a thread amongst what happens with some of our politicians in this country where they tell you, go to court, because they know that what they originally want to achieve would have been achieved. So while you go to court, who knows how long your case will stay in courts before it sees justice.
Well, the thing is, with the administration of criminal justice in Nigeria is hopelessly bad. I know of a number of criminal cases that started about 8 years ago, and the matters are yet to go on trial. And the blame sometimes is on both sides, both the prosecution and the defense. For example, the prosecution, sometimes simple application for bail, the prosecution will start opposing an application for bail. When bail, for example, is the right of an individual, except somebody who is standing trial for a capital offense. And so when you have the delay to hear application for bail, adjournment and all of that, it will have taken a number of years even before you got into trial. But now the good thing is, when they appeared in court yesterday, the court granted them bail on self-recognition so as not to interfere with the business of the legislature. That is fantastic, and I think I commend the judge for granting them that bail. But whether or not the trial lasts longer or shorter depends on how the trial is being handled. I still retain or maintain the conviction that if you are charged, go and defend yourself. There is no denying the fact that there are political dimensions, and anybody who has that interpretation cannot be ruled out that there could be a political dimension to the reason why they are being prosecuted. Because, for example, matters for which the Senate President is standing before Court of Conduct Tribunal, we have some of the governors who are in the Senate right now. During their time also, probably they did not declare their assets, but they are not being prosecuted, but he is. But the thing is, once you are charged, the rule of law demands that you go and defend. You go to the court if it's a criminal trial and expect for that they defend, they prove their case.
How does the court handle those kind of imputations, for instance, wherein members of the public, maybe some members of the public, impute political intentions to all of this? Does the court in any way factor that? I mean, the judges also watch TV, they read newspapers in their spare time. Do they perhaps in any way also think, well, in order for justice not just to be done, but to be seen to have been done, we have to factor in certain things?
Yeah, public policy and the interests of public perception and policy plays a pivotal role in administration of whether criminal justice or court case. And the other thing I want to point out is, even if a judge is driving to the court and right before the judge, somebody shoots someone, if the prosecution fails to bring a very good case before that judge, even though the judge, while driving to court in the morning, actually saw the incident, the judge is not permitted by law to use that experience or what he saw to bring into the matter. That is, when you do that, then you will be seen to descend into the arena of justice. Now, I believe strongly that public opinion plays a pivotal role. However, the court is only bound to operate within the ambit of what is presented to it. Even if you have a strong case, if you don't present it well, you are not likely to get the judgment you want. And then the masses will be wondering that this thing is so obvious, everybody thinks it is this way. How is it that you have not been able to achieve what you want to achieve? It all boils down to the person who goes to court, whether or not you prove your case. But you see, like in this case, for which Saraki, Ekuremadu, and some other persons have been prosecuted in court, you don't have to worry. Our criminal justice system is such that it is, the onus is on the prosecution to prove the element of the offense for which you are charged. Every single element has to be proven beyond reasonable doubt before that conviction can be secured. It is only at the point in which they open and close their case. Then if you feel that they have not been able to establish anything against you, you enter a no-case submission. And if the court rules that there is actually a case, then you go in to defend yourself. But I don't know why the hula baloo behind people wanting to stop trial at all costs. That is what gives concern to the people to start thinking, wait a minute, is it that there is truth in it? Because if I honestly believe I have not committed an offense, you charge me to court, I will go, as long as I know at the end of the day I will be proven guiltless.
What kind of impact does the Administration of Criminal Justice Act have on this kind of case?
Well, the Administration of Criminal Justice Act that came into force in 2015 was designed to bring speedy trial. But I must be honest with you to tell you that I don't know if it is that maybe the details of the Administration of Criminal Justice Act has not been assimilated by the court, by the lawyers, by law enforcement agents, as well as the prison system. Because if you look at it, the Administration of Criminal Justice Act provides that as far as criminal trials are conducted in the federal capital or in the federal high court, trials are to commence every day. And then if there's an adjournment, then the adjournment has a time lag. The Administration of Criminal Justice Act foresees a situation where a criminal trial can be started and concluded before one calendar year. But whether that is being followed is another issue altogether, because we have seen stay of proceedings, which clearly in the Administration of Criminal Justice Act says in criminal matters stay of proceedings will not be granted. We have seen how stay of proceedings was granted in the same Saraki's case. So whether or not the Administration of Criminal Justice Act is implemented, it remains to be seen.
So as a legal practitioner, observing what's been happening so far, how expedient do you think this case is?
Well, I think that we should not close our eyes to the fact that the circumstances that surrounded the emergence of the Senate president cannot altogether be taken out of context as to the reason why he's going through what he's going. And that is why a lot of people hold the opinion that it is persecution and not prosecution. Be that as it may, I feel that we should rather as a country rejoice that there is no absolute rapport between the executive and legislature, because the day the executive and legislature have absolute rapport, the destiny of the nation is being mortgaged. It is only when they have that kind of disagreement that everybody will be on his toe to make sure they do the right thing and they do not allow the other arm of government to subvert democracy. This is not new in Nigeria. If you look at America, you look at how President Barack Obama has suffered in the past 7 years. Some of his proposals cannot go through. There was a time even America was threatened to go into recession if certain decisions were not taken by the Congress. They still didn't do that because of political reasons. So it is not strange. And in Nigeria from 1999, if you look at up to this day, we have attained considerable success. Between 1999 and 2007, we had Senate presidents, about 6 of them or 5 of them changed. In 2006, there was a period where they said even a CCTV was secretly planted in the house of the in the Senate chambers in order to record proceedings or to see observation. Some people interpret that as interference by the executive. Section 4 and Section 5 from the Constitution is clear about the function of these 2 arms of government. Section 4 states that the National Assembly, that's the legislative arm of the government, are empowered by law to make law for peace, order, and good government. But have you also not noticed, in the same vein that we're talking about criminal trial, that the National Assembly is making the moves to amend the constitution so they can divest themselves from the shackles of presidency? They want to amend Section 9 of the Constitution so that the presidential accent will no longer be required when there is need for them to amend the Constitution. In the same way, they are making a proposal to give themselves, the principal officers after their service, life pension. They also want to bring in the issue of immunity on the Senate President, his deputy, the Speaker, and the deputy. Why are they bringing all of this? Now, if you allow that, we have over the years in Nigeria been successful in this democracy without the immunity on the Senate President, the deputy. When Nigerians are even saying that immunity should be removed on the President, the Vice, the Governor, and the deputy, here we are seeing an arm of government trying to bring in immunity. So let us not all together put our hands accusing the executive. Have you also taken a closer look at the legislature and see what they are doing? Are we not witnesses to the fact that there is a problem in the country? How many laws have been passed to cure some of the problems that we face as a nation today? Poverty, recession, unemployment, crisis in the Northeast, crisis in the South, crisis everywhere. Are the members of the National Assembly concerned about that? They have been busy in recent past passing laws that will benefit themselves. The executive, on the other hand, has been busy in the recent past trying to exert their authority on the National Assembly. So it is not strange to me. The rule of law is the most important thing. Like the other speaker rightly said, the president is in court on certificate matter. So if the president is in court on certificate matter, why should the issue of Senate President become an issue as if the end of the world has come?